Thank you very much, Madam President. Madam President, may I immediately express my profound gratitude on behalf of the government for what I consider to be a most refreshing debate today. Excellent submissions coming from all contributors on the government bench, the opposition bench, and also the independent bench. I wish to congratulate Senator Walker for a very strident and confident first contribution. I think that she acquitted herself in fine fashion, and it was certainly refreshing to listen to her in action today. I welcome my friend Senator Sobers back to the bench. He was missing in action in San Fernando West for a little while, but good to have him back with us. Madam President, we are, I think today, united in the purpose of providing protection for the most vulnerable. Senator Richards really brought it home that we're really dealing with a number of cultures all at the same time. What is normal for some, what is age appropriate for someone else, what is now viewed to be blasé, the intersection of the issues of the media core, journalistic core, how the young person views issues of nudity and sharing of images versus someone who's slightly older in the track is certainly something that we as a society are really wrestling with. I have to say that at the Legislative Review Committee, chaired by Senator Rambarat, we have a great deal of assistance in that we encourage all of the young people on that committee to speak up. And on this particular package of laws, because this bill is one of several bills that we have designed to treat with the vulnerable. Bail restrictions, there are other amendments to the Sexual Offences Act that we have carved out, 2 other amendments. This is only one of them. And in treating with it, we really encouraged people who were the youngest in the room to speak up. Because we didn't want to be wrestling with issues from just the perspectives that we have as older practitioners or as people who have been in the dance a little while. And if I may immediately just correct some of the misconception that Senator Mark put on the record, I don't think purposefully. I think it's because the Parliament records were not updated until today. Senator Mark made reference to the fact that we had passed law, and he alleged that, that the laws were languishing, probably because the Parliament record had not been brought up to date. We pointed it out to them. For the record, the Sexual Offences Amendments we did in 2019 were in fact proclaimed on the 31st of January 2020. That's in action already. And for the record, the other amendment to the Sexual Offences Act, and that is the 3rd amendment that we made, that is the 2021 bill that was proclaimed August 18th, 2021, and that is in effect. In relation to the work that is going on with the operationalization of those registers, I can certainly say that those registers are in proper effect. The Trinidad and Tobago Police Service has its online database. That's the private register. You'll recall that there are now 2 registers. There is the public website that you have access to for sex offenders, and then the TTPS has a register of all offenders. And I can tell you that upon the most recent release of a sexual offender, a serial sexual offender, that information went on immediately to the TTPS website, and there is a much better tracking mechanism going on. We have written to the Commissioner of Police to ensure that the websites are continuously managed, because we have a sharing of information from the judiciary. We constantly check to make sure that these things are being coordinated. In terms of the protection of vulnerable, I think it's a useful opportunity, a useful submission. Senator Mark asked about the status of the pepper spray. Permit me to put that into the mix in terms of operationalization. We have dealt with the pepper spray structures. As you know, we passed the parent law. We did the amendments to the Firearms Act. We established the committee to work on the contents of order, the subsidiary legislation, the rules, etc. They have all been drafted. They are with the Commissioner of Police, as is the build-out of the forms and positions. But at the Office of the Attorney General, we completed all of our work. We have written again, third occasion, to the TTPS to remind them that this is something for immediate publication. And I'm told that I should have a response during the course of this week. The order in respect of the order was published by the Minister of National Security. That is the 2021 order, and that he has already identified the strength of pepper spray, the volumetrics, etc. So let's get to the treatment of some of the very large issues that many senators raised. Are we just going to pass another law, catch someone else? Are we going to go upstream, as Senator Walker put it, in reflecting upon Archbishop Desmond Tutu, may God rest his soul? Are we going to find out what caused people to be in the river as opposed to just fishing them out? Senator Richards reflected upon it as well. Well, I'd like to remind that the combined approach for solution that we have taken in the government has been very much materially associated with the changes that we've made at the judiciary. Now, I want honorable senators who are practitioners to reflect upon the fact that in 2015, when I came in as Attorney General, we do remember as practitioners running to the registry to catch the cashier because we had to pay a stamp to file documents. If you were statute limitation troubled and you were rushing to meet the limitation period and 3 o'clock passed you and the cashier gone, you're dead. When we were having the battle of going for a case management conference for 10 minutes in San Fernando, to drive back up to Port of Spain, to have another case management conference, to go to Arima, to get on a plane to go to Scarborough to attend at the magistrates court or the courts in those jurisdictions, we were helter-skelter all over the place. And then came the criminal division, the family and children division, the criminal proceedings rules, the family proceedings rules that were amplified, the children's proceedings rules, the anonymization, the drug treatment court. And I'd like to remind honorable senators that in the criminal division, section 24 of that act is where we birth specialist courts. And the same way the drug treatment court has been born and peer resolution has been born, so that we treat with the root causes of crime. It's the same way sexual offenses are intended, as the Honourable Chief Justice has said quite publicly, and as I say now, to be brought to life in a very different way in the specialist courts for sexual offenses. I can tell you that the judiciary has already begun the move of the civil division into Tower D, where the Parliament used to be. That court is being occupied. There are people already operating from that place. And as we move at the end of this month, all things being equal, into the civil courts being moved to the waterfront, the criminal courts come to life. I've heard people ask whether we need a night court. Well, what about night court? And I'll remind, we have night court as it is. Because you can access a judge from a laptop in a police station for a domestic violence order at Sunday night, midnight. That's Monday morning, 12 a.m. We go to court as it is right now, late in the evening, 7 o'clock, 8 o'clock, habeas corpus. Matters are proceeding now virtually. And I remember vividly when we were passing the criminal division bill, and there was opposition to the criminal division bill. Let me remind, the Law Association of the Republic of Trinidad and Tobago wrote to me and publicly said that they did not support the criminal division. They raised constitutional issues with it. And I had to reply to them and say, listen, you accepted the children's division, and the only difference between the criminal division and the children's division is that under 18 goes in the criminal division for children, over 18 goes in the criminal division. What is the difference? And then we were met with silence. Now, practitioners literally are rejoicing that they can go to court in the fashion that they do from their offices, on their laptops, or from their homes where they have home offices now, without justice being interrupted by the difficulties of moving from place to place for 5 minutes at a time in appearance. And the sexual offenses are going to be found in a specialist court for sexual offenses. In 2015, we didn't have criminal proceedings rules. We did not have virtual appearances. We did not have the filing at midnight, 24 hours a day. We did not have the specialist courts. We did not have the criminal division for children. We didn't have pair resolution. We didn't have the drug treatment court. What we do have right now is an opportunity to further improve the system. And I'd like to say we have completed the parole legislation. We will be coming to Parliament with parole legislation. And associated with parole legislation is treatment in incarceration. For years, we've been talking about what goes on in the prisons. Senator Richards very correctly spoke about the recidivism rate. But if we're not going in to speak to the root causes in the incarceration cycle, then we're missing the boat, which is why we are there with the parole legislation. Much spoken about, but it will come the same way, and I'm sure the older practitioners will know this. You remember, year after year, decade after decade, we spoke about a public defender. We have a public defenders division that is prospering in Trinidad and Tobago. There are approximately 1,260 people in remand for murder. In remand for murder. Do you know that the public defenders represent approximately 788 of them already? And that approximately over 500 people have indicated to the public defenders that they are willing to plead guilty to murder felony? Do you understand the statistical impact of that on justice? Today, in our system, in answer to the questions on operationalization, in our magistrates court, we used to have 146,000 cases in the magistracy every year. 12 divisions, 43 magistrates. Today there are 3 divisions, North, South, Tobago. We merged the jurisdictions of the High Court and the magistracy. We created district courts. We have magistrate registrars, no longer a functionary clerk of the peace. And in this administration of justice, that number of 146,000 cases, we took out 104,000 cases which were motor vehicle and road traffic. And what happened? By Section 20A, Section 20B, and Section 20C of the Motor Vehicle and Road Traffic Act, we changed offenses to violations. And we had a 65-year low in road traffic deaths. 65 years ago, there were bull carts and donkey carts on the road. And we had less deaths last year than 65 years ago. But you see, our country does not sell good news. We don't appreciate the value of change necessarily, and that's okay. It just means we have to work harder at communication. Perhaps COVID got in the way. Perhaps the difficulties of our circumstances are there. But I'm saying all of this in dealing with the operational issues of the courts, in treating with this legislation, to say that the system is radically different. Now, Senator Thompson, Ayi, and I have perhaps a difference of view on the treatment of children And in particular, and I commend Senator Thompson-Aye for her advocacy and passion on the issue of the age of discretion. In some jurisdictions, and the Honourable Senator raised it today, the age of discretion is certainly above 8, which is our law in Trinidad and Tobago. 7 going on to 8. The point is, if you raise the age of discretion, it means that your children are not going into the new system. Understand what the Children's Division does. It anonymizes records, it puts children into rehabilitative programs immediately. It takes them out of conflict with the law. And the question is, do we want to have no interaction with the law? Or do we want to have some interaction with the law? That's something we need to explore a little bit further. But I can tell you they're very heartfelt views for and against. And therefore, that is a conversation that will continue. But the important thing is that the system is radically different today. It isn't perfect, but it is radically improved today. The association in the specialist courts and the type and remedies that we have in particular for children as we amend in section clause 6 of the bill, the consequential amendments provide for voyeurism, taking and sharing intimate images, and then compensation in the suite of the children's laws, the Children's Act. But in looking at that particular provision, I want to remind that in the Children's Court, the range of remedies in the Children's Act, section 54 of the Children's Act, other sections of the Children's Act, even when we're dealing with incarceration in child rehabilitation centers, there is an entirely different system in place. Because we no longer have the system of you are incarcerated and you can't get out. Lest we forget, we amended the law. As Attorney General, I piloted the law to ensure that the Commissioner of Prisons, the managers of child rehabilitation centers and children's homes can actually have children go out and go to school and receive treatment and receive counseling and receive care. We are in a different environment, Honourable Senators. I should add that we have further amendments as we treat with prisoners on the remand side. There are amendments to the prison's rules that we have drafted, and we are in a completion of an exercise in combination with the Canadian government for the work and structure in our prisons. It comes back to the maxim of plant and machinery, people, processes, and law. And what I can say, if you look at where the children's package is, if you look at the Sexual Offences Act as we amended today, you look at the fact that we had a register for sex offenders since 1999. And for 20 years, because in 2019 we amended it, not one person was put on the register because the law was just not properly constructed. I can tell you that our systems are up and running. The digitization program is critical to where we go. And that digitization program is already working. You see it in the courts. That is a remarkable achievement for the Republic of Trinidad and Tobago. And the Honourable Chief Justice, who has been the architect of reform at the judiciary in driving that push, is to be commended. The government has done its part. The judiciary is doing its part. So let's get to a couple of the observations on the bill. So we definitely believe, whilst the bill has a great legitimate aim, whilst we're all agreed that we want to do more, there are a few four cornerstone issues that we have to address. We have to address the issue of the voice of the child. Who gives consent? At what age can consent be from the child as opposed to the person with responsibility for the child? Where do we deal with the issue of disapplication of the law? Do we deal with it in the individual sections, 22A, 22B, 22C? Do we carve out the disapplication? What do I mean by that? You shall not commit an offense if it's your lawyer who's dealing with the matter, if it's law enforcement who's dealing with the matter, if it is in certain circumstances appropriate. Those are matters that we can architecturally remove from the individual sections and put into sweeping clauses in the section to say, with respect to 22A, B, and C, you shall not be committing an offense in the following circumstances for the following persons. I think that the issue that is largest to canvass is going to be the public interest issue. Because if I give you the example that comes from Canada and from the United Kingdom and you blend it, the Law Association also raised the public interest issue. But I want to remind that there was a case recently of a child who was drugged, parts of the child visible, naked, in part, clothes falling off. The child's anatomy was visible, teenager. In the video taken, the person who was with the child claimed to be the child's parent, if you recall, father. That video may or may not traverse some of what this law is about. But that video, which allowed law enforcement to go to work, was in the public interest. So we had to contemplate a provision of finding a way for circumstances outside the stricture of the law and leaving it to the discretion of the court. Now, Senator Walker asked for more detail in the law. What we have proposed is in keeping with the architecture of the Sexual Offences Act, and that is framework legislation where the actus reus, the elements of the crime, the acting part of it, is specified in the nature of how a crime should be specified, with mental intention of knowledge being required in these circumstances, because you have to protect against the innocent infringer. But when we get to the public interest argument, and you look to the Canadian and UK laws, we did note, particularly in England, that there was a code for Crown prosecutors, and that they did include some of the factors such as these: whether the offense is likely to be repeated, the extent to which the offense was premeditated, whether the victim was targeted, whether the offense was motivated by sexual gratification, etc. And I remind that in the Sexual Offences Act, we amended it in 2019 to allow the rules of the Supreme Court to speak, so that we can have rules of the Supreme Court to assist us on directing elements now that we have criminal proceedings rules. I want to remind that we had no criminal proceedings rules prior to my tenure as Attorney General. It was in this government's tenure that we developed these rules, and these rules make for important improvements in the law. So this law is intended to be further particularized by the rules of the Supreme Court, and there is also the regulatory provisions that we can have by way of subsidiary legislation. So this is not intended to be a vague description of law. It is intended to work in tandem with subsidiary legislation, either in the form of regulations or in the form of the rules of the Supreme Court, which already have been operationalized in the form of criminal proceedings rules, whether they relate to children in the children arena or adults in the criminal proceedings rules on the adult side. Madam President, the other submissions by honourable senators are specific. Nomenclature, technology, the inclusion of audio, the description of authorized persons, etc. These are things which we will traverse with proper explanation. For instance, we took the authorized persons from the concept of qualified persons, and we brought that from another piece of law when we were dealing with children, where we defined who the child could speak to as a person who could assist the child in difficult circumstances. So there are rooted, well-anchored explanations as to why we have taken the terms and conditions that we have brought forward. And therefore, Madam President, I believe that in the course of a special select committee, we can get into exploring those mechanisms. Now, why not a joint select committee? I respectfully believe that the Senate has it within its grasp to conduct this work in a more efficient fashion than an entire joint select committee. We've done it successfully before. If you recall the work we did on plea bargaining, we did a phenomenal piece of work on plea bargaining as a special select committee. And therefore, I think it well within the realm of tolerance for us to urge...
Attorney General, you have 5 more minutes.
Thank you, Madam President. For us to urge the production of this work in a special select committee. We will not be losing any of our effort in that regard. There are a number of precedents that we will, of course, bring forward. We've had the benefit of a lot of stakeholder consideration, but now we really need to get down to some of the nitty-gritty. Is this, in its form, appropriate for Trinidad and Tobago? In our discussions at the Law Revision Committee, we were talking about our standpipe culture. As a scout at first presentation, Sea Scouts in San Fernando, I fed up bait on the standpipe. Literally, it was an experience of life in San Fernando. Is that appropriate? Are you in public? Are you not? What about communal areas? Senator Rambrat wasn't joking when he said we spent a lot of time on babies. Your child is without covering. The baby's bottom is shown in a picture. It was in a house. It's why we dealt with the surveillance for homes, because we live in close communities and somebody has a surveillance camera in their yard and somebody's in their other home nearby and the camera has sight of it. Well, that wasn't an actual purposeful infringement. Was it an innocent infringer? Are we going to go into private life issues and trigger 3/5 majorities? Are we going to require cameras to be identified in private homes if they are meant to be covert cameras for security purposes or not? All of those are issues that are not novel to Trinidad and Tobago. There is precedent and there is reason, but we have to look at this in a Section 13 type consideration of the Constitution. Is this reasonably justifiable, even though we don't need a special majority? Is this reasonably justifiable in a society that respects democracy in the way Trinidad and Tobago respects democracy? So, Madam President, it has been honestly a privilege today to sit amongst all senators again on, I think, a very unified purpose that we all share. I wish to thank honorable senators for their sterling contribution. I know that Minister Mitchell was itching to speak today because he did a lot of work at the law revision end of the committee, but gave way in the interest of time. So there were many others who perhaps wished to speak today. And I'm confident that when we come back out of committee, that we would have a better product. In those circumstances, Madam President, I beg to move.